of the first and second accused. I exercise the powers of the DPP, the delegated powers of the DPP under Article 157. I swear it is not part of our work to detain or arrest. I swear. That power is granted to the National Police Service under Articles 243 to 245 of the Constitution.
That is the power to...
The power to arrest, police power to investigate and arrest. Although under Article 157, sub-article 4, or is it 5, the DPP has powers to direct the Inspector General of the Police.
Because the orders are against the DCI, DPP, and the IG. So I just wanted to understand he's trying to excuse the IG and the DCI.
No. I'm not excusing any of us. It's admitted from when I started that
Do
the
I
DPP...
have a copy of the ruling?
Yes,
Yes, we passed on all the rulings to you.
The only thing you may not see is the parties, which I admit the DPP
You're
is.
referring to me petition.
This is E396. E396 of 2024. The one I have, you may not see the parties, but we admit that the Director of Public Prosecutions is the second respondent. What the DPP through me is telling the court is that we are not mandated to arrest and or detain anyone, the DPP. Related thereto, the DPP did not arrest nor detain anyone. However, the DPP has brought these charges before you this morning under Article 157, sub-article 6, sub-article A. That distinction in the roles of the DPP and the police is very important. So that for the DPP to bring charges before you, even this court on its own motion, like some time back, could summon somebody before court on the basis probably like good an example of inquest proceedings. And the DPP would later charge that person without them having to be arrested or detained. So that our role in this court this morning is to look at the propriety of the form and substance of the charges. The question as to the arrest and or detention and or possible contempt of the orders of Honorable Bahati Mwamuye are matters that, as we have said, are out of your jurisdiction, and as we admit from the defense side, are live before Honorable Bahati Mwamuye. So that by the DPP charging the suspect before you is not in violation of any court order. The Director of Public Prosecution has not detained, has not arrested, has simply charged, and is therefore not in violation of any of the orders, whether prayer order number 1, 2, all the way, none of them. An argument can be made that the police possibly are in breach of the orders of the High Court. This court has no jurisdiction to consider that. That matter is live before Honorable Bahati Mwamuye. The parties will address those issues before the Honorable Bahati Mwamuye with respect. There is no effect on the exercise of the mandate of the DPP by any of the other respondents having violated, if at all, these orders. Because the DPP is not in contempt, if at all.
Let's not forget the DPP is a big advisor. The DPP is divided by two.
Yeah, I'm almost done. There may arise, as a preemptive, there may arise the issue of the effect of a possible finding of violation or breach of the right of the orders of Honorable Banti Mwamuya. Because this has been raised before by counsel appearing before you. In Julius Kamau Mbogwa versus Republic, Julius Kamau Mbogwa versus Republic, this is criminal appeal number 50 of 2008, 50 of 2008. It is reported in the Kenya Law Reports in 2010. This is what the Court of Appeal had to say about the effect of violation of rights on criminal charges. The bench was made of a very powerful bench of judges, E.M. Githinji, P.N. Waki, and Al-Nashir Bisa. And this is what they said, in, if I may quote, the breach of a right to personal liberty of a suspect by police per se is merely a breach of a civil right, though constitutional in nature. Which is beyond the statutory duty of a criminal court, and which is compensatable by damages. That the Court of Appeal, which is binding on this court by the doctrine of stare decisis, has held that even where there may have been a violation of the right to personal liberty, as in the circumstances before you, even if this court were to have had jurisdiction on that issue, which we submit you don't, then the remedy would have been in damages and not a quashing of the charges. That law remains law, binding on this court. We are aware that the Honorable Justice Aburili has in Siaya, in Charles Odhiambo alias Ogis, delivered on 30th of January 2023, held that a violation of rights would lead to a quashing of charges. We humbly ask this court that you are bound by the Court of Appeal, and that court in Siaya is equally bound by the Court of Appeal. Stare decisis. In response, in summary, therefore, can this court reject charges? Yes, but not on the grounds provided. Is there a basis to reject charges? No. Because the charges meet the provisions of Section 134 of the Criminal Procedure Code, which is the test. It also meets the requirements of Section 89 and therefore cannot be rejected under 89.5. Can this court stay the proceedings? No. That is the jurisdiction of the High Court under Article 165. For whatever reason, you can't stay proceedings. Can this court exercise inherent jurisdiction, or what is called discretion, not in criminal cases? This is a criminal case. Can this court throw the charges into a dustbin? There's no legal provision for that. As I conclude, if the defense intends the Director of Public Prosecutions, as has been mentioned, reviews these charges, the DPP has to be moved. We are welcome to receive letters for possible review of the charges. We act independent of the police or National Police Service, and instructions from the DPP that we can receive applications from anyone, including the accused persons, for review of charges. I submit. Thank you.